Good morning. You're Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson was previously in court, entered pleas of guilty in all three of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
I'd just like to address one thing that Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think. And I'll ask my client to clear it up. Now, you're working for a home health care agency, is that correct? And
Answer yes or no, please.
And your client at the time had asked you to dispose of some personal banking checks, is that right?
Yes, and I took them. I misspoke. I meant to say I took the checks, and I knew that Adrian Hayward was going to cash them, so I'm just as guilty as him.
Of the four.
So, and she said in here that she's the one who took them.
Yeah.
So I'm okay with that.
Brought it up, and
Okay.
I had to clear up culpability.
I appreciate that. Yeah, I agree.
They've never caught AJ.
No, I've been hearing that he's incarcerated or whatever, but I haven't been around.
Okay.
Thank you.
Any other issues?
No, Your Honor.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shelton, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss him, but I didn't have paperwork on probation.
Okay. What?
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the, won't abandon and get some of the CPS rules. I didn't see that.
Well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and
We can go talk to Judge Shelton, maybe, or no, this is fine.
no, I mean, that's as long as but she's going to have to give her probation officer documentation from CPS. So you can work that out with your probation officer. So mine's going to be no unsupervised unless, and then if probation gets that information and she's doing her safety plan and everything, then we're going to be okay with that here also. But they're going to kind of be the ones that dictate that process, not me.
Just kind of nebulous. A couple conversations with appointed counsel on that, and a couple conversations with the caseworker.
Okay. All right. So Ms. Johnson.
Done is what they told me, so.
Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right, good luck to you, ma'am. Thank you, Mr. Frazier.
Thank you.
Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God?
Yes, Judge.
Thank you. Are there any immigration issues?
No.
Okay. I didn't see any listed in here. I just wanted to make sure. Jody, I'm not sure if I'm going to do this, but for Spanish speakers, non-English speakers, ISF, things like that, do they have accommodations for that? Okay, let me hold this for just a minute because that's something that I'm considering just based on age and the nature of the offense. If you'll just let them know, we'll pull him back out in just a second. Good morning. Are you Federico Ortiz?
Yes, ma'am.
And will your client waive the formal reading of the motion and the indictment?
He will.
Mr. Ortiz, in cause number 25, DCCR 0589, you're charged with the state jail felony offense of abandoning or endangering a child, and that's from December 1st of 2024. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In that case, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Ortiz is not competent?
No, Your Honor.
All right, sir, in that case, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, in cause number, let me find it. 24 DCCR 2334. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 10th of 2025 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the months of May and June of 2025, and then also July of 2025. Is that true or not true? And then count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
True.
Then count 3 alleges that you failed to provide verification of completing the theft prevention class as ordered. Is that true or not true?
True.
And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I also have here on the tablet, in this case, some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over this with Mr. Rojas?
Yes, ma'am.
And do you fully understand them? State tenders number 1?
No objection.
It's admitted. Mr. Ortiz, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm handing you the trial court certifications that shows that there are agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir. You can go back with the bailiff.
Thank you. Thank you, Your Honor.
Thank you.
And thank you, Mr. Rojas.
All right, sir, you're Dalvius Williams.
Yes, ma'am.
And Mr. Williams, in cause number 25 DCCR 0176, you're charged with a third-degree felony offense of injury to a child, and that's from October 28th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year term in the institutional division. I'm assuming that would run concurrently with the time that you're currently serving. You have every right to reject that and have a jury here and decide your case. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
I do want to make sure you understand, Mr. Williams, that after today, I will not accept this plea agreement. Once your case is on the trial docket, it'll go to trial, or you can change your mind and plea open to me or plea to something different, but it's not going to be this plea agreement. Do you understand?
Yes, ma'am.
I just don't want you to think that you're going to sit in jail and things are going to get better somehow, right?
Yes, ma'am.
Okay.
Judge, I would also like to put on the record that if he's rejecting this offer that would run CC, the state will file to have this, whatever he receives in this from the jury, to be stacked on top of what he's already received on the interior.
So I do want to make sure you understand, depending on the timeline of all that, there is the possibility that if you're found guilty in this case and whatever punishment you receive could be stacked or run consecutively to that sentence that you already received. Do you understand?
Yes, ma'am.
And do you still want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get that done. Mr. Williams, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint someone else today that can begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Rojas, you are released. Mr. Williams, we will appoint someone today, and they will begin preparation for trial. All right? You can get back with the bailiff. That may be one that we try to find a space for to get taken care of. He just wants to hang out in our jail. Good morning. Are you Romeo Johnson?
Yes, ma'am.
And this is cause numbers 24 DCCR 2095 and 2419. Mr. Johnson's cases are set for trial to begin with jury selection next Monday. What is the announcement?
We're ready, Your Honor.
All right. Anything that changed in negotiations that we need to go over today?
I was given some additional discovery materials, but it's just a complete autopsy.
Okay.
So there's no new offer or anything for me to present to my client.
I'll entertain a counteroffer.
All right, if y'all want to visit this morning, just to double check if there's any counter offer or anything like that, let me know. I'll hold it for a minute. Otherwise, it'll get numbered for trial.
Yes, Your Honor.
Okay, thanks. All right, so you are Daniel Yarborough?
Yes, ma'am.
And Mr. Yarborough, in 24 DCCR 1722 and 24 DCCR 2289, charged in each of those cases with theft of property. The cases are set for trial to begin with jury selection Monday, the 29th. And what is the announcement?
Your Honor, I'm ready. I do think Mr. Barbo has endeavored since our previous setting to go through rehab and has accomplished some things that I'm going to provide to Mr. Coleman that may perhaps change the plea offer, but I am ready for trial. But we do have additional stuff I was going to tell you in the prosecution.
Judge, this case, in all honesty, should not be in the trial. I am willing, if the court will put this case on recall, to take a look at what he's providing. I may make an alternative offer. Unfortunately, the file's not in my bucket. I need to get someone to bring it
I'll
down.
hold it while y'all take a look at all of
You
that.
want to say something?
Just, y'all,
Judge, I
hang
think
on.
this is inappropriate.
Yeah, not yet. Y'all visit. This is between y'all right now, okay? Let's see, Mr. Philip Smith on Carrington Scott. Like I said, because I got used to that yesterday, saying your first name, because we had a hearing with Bruce and Philip yesterday, so I had to,
One way it gets more fun is if the defendant's last name is Smith also.
I know. All right, are you Carrington Scott?
Yes, ma'am. How you doing?
Good. And Mr. Burbank, will your client waive the formal reading of the indictment?
We're proceeding on the lesser included, Judge.
Thank you. Mr. Burbank already alerted me as well. Appreciate that. Let me get that pulled up the right way. Mr. Scott, in cause number 25, DCCR 0538, the state has elected to proceed on the lesser included offense of a state jail felony theft from a person, and that's from March 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, state's one.
It's admitted. Is there any evidence that Mr. Scott is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft from a person, sentence you in accordance with that agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank.
One other thing.
Yes, sir.
There's a pending felony, misdemeanor, out of misdemeanor court. I don't have it. It's resisting this incident, and Mr. Smith said he was going to dismiss it as part of it.
Okay, and so Mr. Smith, you'll take care of that down in misdemeanor court, and they'll get that case dismissed quickly, all right? You can go back with the bailiff, sir. All right, you're Kaylin Salzar. And Ms. Salzar is on probation in cause number 24, DCCR 2234, and that is for a misdemeanor offense, or a case that was reduced to a misdemeanor. It's an unadjudicated probation. She was placed on that probation April 21st of this year. And it was a criminal mischief that was reduced to an attempted criminal mischief. A motion to revoke has been filed, or motion to revoke unadjudicated probation. It alleges a DWI from August 23rd of 2025. It alleges a failure to report in August, failure to perform community service, behind in court-assessed fees, that she admitted to using alcohol in violation of her probation, August 23rd of 2025, that she has not completed a cognitive thinking class as ordered. And in addition, we have a pending felony case of assault on a peace officer with an offense date prior to her getting the probation in this case. And so that's not alleged, and it's standing, I guess, on its own at this point. Mr. Kimler has filed a motion asking that I set a bond in the misdemeanor probation case where she's on an unadjudicated probation. Mr. Nichols, what's the state's position on that?
Your Honor, in addition to the two cases before you, she has two separate DWIs that are pending lab results that have not yet been filed. One is from March and predates this probation. One is from is what's listed in the motion. It looks like the only thing holding her is the bond on this case, and if she's in light of those arrests and what's alleged in the motion, if she's going to be granted a bond, I ask that it be interlock. And
I would suggest she not be allowed to operate a motor vehicle, period, instead of an interlock. If she does have the interlock, I don't think she needs to drive at all. But she wants to go into rehab, Your Honor, and that's really the purpose of me trying to get her a bond. Where have you talked about?
Well, and here's the thing, you don't get to pick all of that. She's on probation, so that has to go through probation. In addition, we have another case pending that, depending on the length of everything, I'm not just going to put off. And so obviously, if there needs to be some rehab, then I'm all for that under the right circumstances. But if you make a bond, you can't just go off somewhere without it being approved by probation and ultimately by me, so that we know what that is, where it is, and what that means with regard to that assault on a peace officer case.
That's her intent. She does recognize that she has an alcohol problem. I've talked to her extensively about that.
Hold on a second. So, Mr. Nichols, any other input?
if it's not going to be, and I agree that maybe her not driving at all is probably the best course, but there needs to be some sort of monitoring, like a scram or something along those lines, Your Honor.
I agree. So what I'm going to do, Ms. Salzar, in cause number 24, DCCR 2234, is to grant that request for me to set a bond. I'm going to set the bond at $10,000. Condition of that bond is you are not allowed to drive anything, no vehicle, period, ever. You will be required to wear a scram device. Obviously, if that tests positive for alcohol, then you will be in violation of your bond conditions. That bond's going to get raised, and you'll be able to wait all this out while you're in jail while it gets sorted out. Do you understand? Any other conditions?
I think that should cover it, Your Honor.
Okay, and so what I'll do then is we'll reset, a normal reset, and see what we need to do on this, obviously, as well as the other pending felony.
And then she needs to report to her probation officer as soon as you make bond.
Yeah, you're still on probation, so go straight to your probation officer, talk to them about what you need or can do, and then go from there. Okay.
And stay in touch with your bonds.
Good morning. Are you Randolph Fines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Fines, in cause number 25, DCCR 1154, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but lead to charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, I've said it so many times. But I can't stop in the middle and then restart. That's not good.
I contacted him and he was sitting in the Beaumont Municipal Court waiting for his name to be called. So I
Oh, wrong.
apologize for that.
Yep, a lot more serious than that over there today. Mr. Hoffpower, this is yours. I'll recall the bond forfeiture. And this is cause number 24 DCCR 1998. Mr. Turner's charged with criminal mischief. And what is the announcement?
Judge, we're just asking for more time to review evidence. We haven't had a chance to do that yet.
Okay. And any issues?
No, Your Honor.
All right, so I'll just do a normal reset. Make sure you stay in touch with Mr. Galmore so you can go visit with him before that next court date. We'll see if we can get an announcement. All right.
Thank you.
Thank you. Good morning. Are you Christopher Street? And this is 24 DCCR 2058. Mr. Street is charged with theft of property. And what is the announcement?
Judge, we got a revised offer this morning, and if we could just have one more standard reset, my client needs to come up with a restitution upfront in full, and that is his intent to do that, and I think we could get this resolved at the next setting.
All right, so this will be the final reset. Looks like you were hired back in January, so this will be it. If you get the restitution, great. It'll take care of however y'all, whatever. If not, there needs to be something else that you guys are discussing just in case, okay? We'll see you at the next court date.
Thank you.
When's the last time you smoked marijuana? Tell the truth. Because what's gonna happen is I'm gonna get amounts, the levels, right? So tell me the truth. When's the last time you smoked? That's the truth? Have you done anything else? Speak up. Promethazine? When's the last time you did that?
What is that?
Cough syrup. Anything else with that?
Judges, obviously, up to the court's discretion, but we're definitely going to reserve the right to dismiss the ISF, properly substance abuse track.
How old are you? 19? All right, so I guess what I would rather do, I want to go ahead and get the process going if he's got a plea agreement. But I think based on his age and the nature of the type of drugs he's using, I am going to raise that bond. We'll get the pre-sentence report done, see if there's any issues with regard to substance abuse and if there's any upfront that treatment that I find necessary at that point. So let's go ahead and go through the plea. And will he waive the formal reading? I know we started it, but
He's already
we're going to go
pled
back.
guilty. He said freely and voluntarily, and that's about where you left off.
All right, and so did you plead guilty to this offense because you actually did what they charged you with? You didn't? You didn't do what they charged you with? Look at me and pay attention, all right? Okay? Everything's going to be okay, but you're young, and if you're going to be successful on any kind of probation in life, you're going to get some help early on right now so that you don't end up with a felony conviction, okay? But I need you to pay attention to my questions and listen very carefully and answer them. So, you're charged with burglary of a building. The question I asked is, did you plead guilty because you actually did that? Okay. I have here on the computer some documents that have your signature on them. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Just pay attention to me right now. Do you understand the papers that you signed on the computer? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I go along with this agreement, you can't change your mind later. Do you understand? And it looks like the agreement's for a 4-year deferred probation, that there would be restitution ordered, which means you would have to pay back some money for any damage or whatever you stole, and they'll figure that out before sentencing. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Martin is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so we can get a pre-sentence report done. If possible, I'd like to get some type of substance abuse evaluation done and any recommendations, as well as we'll get that restitution figured out, and then we'll come back later for sentencing. Based on the nature of the plea, based on your age, and the fact that you tested positive for THC and admitted to using promethazine, I am going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times. So probation's going to come out to the jail, talk to you, we're going to figure out what all you need, and then we'll get you hopefully started in on this probation where you can be successful. All right? Go back with the bailiff. Thank you.